Good afternoon, everyone. I think we're going to start. Thanks for joining us today for a presentation on the revised draft policy guidance for residential adaptation to sea level rise. My name is Mary Matella, and I'm an environmental scientist at the Coastal Commission, and I'm joined by other members of the Commission Sea Level Rise team here in San Francisco. Due to the number of people on the call, we're not going to open the lines for questions via phone, so just please enter your comments or questions in the chat box of the web interface on GoToWebinar so that we can be ready to answer as many questions as possible after I'm done presenting. Note that this webinar will also be recorded and posted later on our website. I'll begin with an overview of today's presentation. We released the second public review draft last week on March 6th. You can find the revision of our policy guidance on the website noted on the bottom of this slide. Revisions were made after Commission staff reviewed feedback from commissioners, Commission district staff, local governments, agency partners, NGOs, and the public during the public comment period. These revisions include organizational changes, more model policy language and user note clarifications, additional explanatory information for application of the model policies, and a variety of minor editorial changes. The first draft guidance was released on the Coastal Commission's website on July 28, 2017 for a 2-month public comment period. To solicit and encourage comments on the draft, Commission staff conducted 3 public webinars, 3 conference calls with local governments, and meetings with our district staff. 27 comment letters were received from private citizens, NGOs, local governments, state agencies, and others. The comment letters are posted on our website on the Residential Adaptation Policy Guidance page, and detailed responses to the public comments will soon be posted on our website as well. An email will be sent to our mailing list when these are online. So first, a little bit of project background. The Residential Adaptation Policy Guidance is a next step and builds on the Coastal Commission's 2015 Sea Level Rise Policy Guidance. The Residential Adaptation Policy Guidance provides a more in-depth discussion of sea level rise adaptation policies specifically related to residential development and sample policy language that cities and counties could modify for use in different community and geologic contexts. The overall goal of this project is to ensure that shoreline development and redevelopment is resilient to coastal hazards while maximizing protection of coastal resources such as public access to the beach and shoreline, recreation, visual resources, and shoreline ecology along the coast. This guidance, when finalized and adopted, will be a tool that local governments can use as they update local coastal programs, or LCPs, to address sea level rise hazards. So here's a brief overview in this slide of the new organization of the revised draft guidance. There are 6 sections. The first 5 sections serve as a type of application guide for how to use the model policy language to update an LCP. It describes background on LCP planning, residential development, and the challenges that sea level rise presents for different types of hazards and development, and principles that apply to all hazardous areas, as well as strategies for specific types of areas. Sections on legal considerations and implementation also follow. The final section comprises about half the document and presents model policy language. We also added an appendix to highlight funding opportunities. So many similar themes and comments were repeated in multiple comment letters and other feedback. A summary of the major changes to the document, along with comprehensive responses to the more frequently asked questions, or FAQs, is currently on our website. I'll also summarize some of the FAQ themes here with you today. Note that the FAQ document goes into more detail on these responses than I will here, so please look to our website for that information. Many commenters questioned the intent of the draft guidance and how it should be used. The draft guidance is not a regulation or a mandate. However, it does provide the Commission's direction on how LCPs should address sea level rise. Using the model policies can help ensure Coastal Act consistency, but jurisdictions remain free to develop other policies so long as they are consistent with the Coastal Act. The draft guidance is not the legal standard of review for the actions that the Commission or local governments take under the Coastal Act. Such actions are subject to the applicable requirements of the Coastal Act, the Federal Coastal Zone Management Act, certified LCPs, and other applicable laws and regulations as applied in the local context. Now, some of the model policies contain terms such as shall or other mandatory language because they are presented as examples of possible language to use and are shown as the policy would appear in an LCP. This presentation of the information does not transform this draft guidance into a regulation or a new legal standard of review. Rather, it reflects the fact that LCPs often need to contain policies with requirements in order to be consistent with and adequate to carry out the Coastal Act. The model policies are written for local governments to customize and create their own LCP policies, and in many instances, such policies may need to include these requirements. Also remember that this draft guidance deals only with residential adaptation. Different tools and strategies may apply in the context of adaptation planning for infrastructure, coastal-dependent development, public beaches, and other facilities. You can read more of the FAQ number 1 for more on this discussion topic. The next theme relates to shoreline protective devices for existing structures. Broadly speaking, it is important to address when the Commission is required to approve shoreline armoring because armoring causes a variety of impacts that are inconsistent with the Coastal Act's resource protection policies and can reduce public access. Interpreting the term existing structures for the purpose of Coastal Act Section 30235 is critical in order to appropriately define when structures are allowed to obtain shoreline armoring that harms coastal resources. Section 30253 sets forth design and siting requirements for new development. Read together, the most reasonable and straightforward interpretation of Coastal Act Sections 30235 and 30253 is that they demonstrate a broad legislative intent to allow shoreline protection for development that was in existence when the Coastal Act was passed, but to require any new development approved after that date to be designed and sited in a way that avoids the need for shoreline protection. Construing the term existing structures in Section 30235 to mean pre-Coastal Act structures is the most consistent with the language, context, and history of the provision. Otherwise, the Commission and local governments would be required to approve applications for shoreline protection in far more circumstances, including far more circumstances where the armoring would have significant negative impacts on coastal resources. Importantly, defining existing structures as pre-coastal will not necessarily preclude structures built after 1976 from obtaining shoreline protection in appropriate circumstances. If a residential structure does not qualify as existing under Section 30235, it means that the Commission or applicable local government is not required to issue a CDP for armoring in circumstances where such armoring is inconsistent with relevant LCP or Coastal Act policies. However, the owner may still be able to obtain a permit for constructing or altering a shoreline protective device if, for example, the protective device in that location is necessary to protect adjacent structures that are allowed protection pursuant to Section 30235, or if it would be consistent with all relevant Coastal Act and or LCP policies, as might be the case in some bulkhead situations, for example. To clarify the Commission's guidance, we added a revised flow chart for shoreline armoring for residential structures in Section 4 of the document and called out a subsection describing the issue of adaptation strategies for development constructed after January 1st, 1977. Here we highlight the case of urban infill and note that shoreline armoring may be an allowable adaptation strategy, at least in the short or midterm, in order to protect areas where new and existing residential development are intermingled, and it is not feasible to have the shoreline armoring only protect the existing development. We also added user notes to Section 6 armoring policies and an appendix to the FAQ to provide even more discussion on the many points related to defining existing structures that were brought to our attention following the release of the first draft guidance. The next themes relate to redevelopment and how to differentiate that from repair and maintenance. Definitions of redevelopment are common in land use planning and help to complement policies in the Coastal Act. One reason to define redevelopment is to avoid the conversion of an existing non-conforming structure into a new non-conforming structure through a single renovation or incremental changes to the structure. Failing to define redevelopment and thereby allowing unlimited cumulative repair and improvements over time could allow piecemeal complete redevelopment of a non-conforming property in a hazardous location. This result is directly at odds with Coastal Act policies that require new development to minimize risks and protect coastal resources, including public trust resources. The model policy defining redevelopment in the document is primarily intended to address situations where major structural elements of a building are replaced. Generally, routine repair and maintenance of and improvements to residential structures are exempt from coastal development permitting requirements unless the structures are located in sensitive habitat areas or directly adjacent to coastal bluffs, beaches, or the sea. Normal maintenance or improvement work, such as reshingling a roof, repainting or replacing siding or plumbing fixtures, or remodeling a kitchen, would not normally trigger redevelopment standards because they would not affect major structural components of a home. Additionally, if an LCP defines redevelopment to include development that costs at least 50% of the market value of the structure, it is unlikely that routine repair and improvements would meet that standard. However, local governments can tailor redevelopment definitions to some extent to ensure that they will make sense in that particular jurisdiction. We added more user note discussion of these points in the revised guidance. Another frequent comment related to shoreline armoring focused on mitigation. Some commenters asserted that Section 30235 only specifies that impacts on local shoreline sand supply must be mitigated, and that it does not require mitigation for other impacts of shoreline protection. Section 30235 contains some standards applicable to shoreline protection, but other provisions of the Coastal Act, its implementing regulations, and the California Environmental Quality Act also apply. These provisions require agencies to analyze alternatives to shoreline protection and to adopt an alternative that substantially lessens any significant adverse impacts that the protective device might have on the environment if feasible. We further described armoring impacts and potential mitigation in the Model Policy F3, Siting and Design to Avoid and Mitigate Impacts in the revised draft guidance. Another frequently noted subject of comment related to public trust lands and the role of the State Lands Commission and the Coastal Commission. An important consideration for jurisdictions planning for sea level rise is that in many locations the public trust boundary will migrate inland as sea levels rise. As described in the legal considerations section of the revised draft guidance, the ordinary high water mark, which is generally measured by the mean high tide line, delineates the boundary between public and private property. If the shoreline naturally accretes and the mean high tide line moves seaward, then the property line generally moves seaward as well. But if it naturally erodes, or if the sea levels rise and the mean high tide line moves inward, landward, then the property line generally moves inland as well. What used to be private dry land does not remain private. Rather, it generally becomes public property that is subject to the public trust. The state and local governments, including through their Coastal Act obligations, have a duty to protect such property for public trust uses. Public trust uses include maritime commerce, navigation, fishing, boating, water-oriented recreation, visitor-serving facilities, and environmental preservation and restoration. As described in the draft guidance, the State Lands Commission and the Coastal Commission have separate but complementary roles to play in protecting public trust resources. For example, the Coastal Commission must ensure that applicants for new development have adequate legal title to the land underlying the proposed development. A failure to demonstrate such legal title is a ground for denial of the development. Although the State Lands Commission has sole authority to determine whether to lease a public trust land under its jurisdiction, local governments and the Coastal Commission both have the authority and duty to regulate uses of land in a manner that protects the public trust. One way to carry out this duty in part is by requiring applicants for development on private land that may be subject to sea level rise to submit periodic evidence that this development remains on private property. The revised draft guidance offers a new model policy, D3, Mean High Tide Line Survey Conditions, which demonstrates how local governments could implement permit conditions related to surveying the mean high tide line. We also note in Model Policy F8 related to shoreline armoring monitoring, how monitoring plans for shoreline protective devices could trigger a mean high tide line survey. The need to protect the public trust is also emphasized in revisions to Model Policies B2, removal plan conditions for new development in hazardous areas, B3, reliance on shoreline armoring, and D1, removal conditions and development duration. The next theme relates to funding. Some commenters stated that the costs of implementing adaptation measures are not addressed in a meaningful way in this document. The Commission is aware that adaptation approaches will require significant funding in the future. To address this need, we added a subsection on funding to the implementation part of the draft guidance, as well as an appendix of potential funding sources. The Commission recognizes that funding opportunities are constantly evolving, that demand for funding is increasing, and that there is a significant need for the development of additional funding opportunities to plan for and implement adaptation to sea level rise. Several of the model policies also address this need. Model Policy G12 identifies the option of forming geologic hazard abatement districts or county service areas, currently Model Policy G12. And in addition, a new Model Policy G13 has been added to identify options for project funding that might overlap with LCP adaptation from other programs such as the Federal Emergency Management Agency's Hazard Mitigation Assistance Grant Program. The last theme from the FAQ is managed retreat. Many commenters stated that retreat is not a feasible option for adaptation in their communities. While the Commission understands that managed retreat will be difficult to implement in many locations, it is important to consider the range of feasible adaptation options that are available and to choose strategies that align with the Coastal Act and LCP objectives. We revised the draft guidance to include additional context for potential challenges and opportunities for implementing retreat-based approaches. We note how California beaches, both wide sandy beaches and pocket beaches, as well as many nearshore coastal areas, are significant financial and recreational assets to coastal communities and the state. Beaches and other shoreline areas also provide remarkable ecological value, including unique and important ecological services such as filtering water, recycling nutrients, buffering the coast from storm waves, and providing critical habitats for many species. When beaches and other habitats backed by fixed development are not able to migrate inland as sea level rises, they will become permanently inundated over time, which presents serious concerns for future public access and habitat protection. Retreat strategies might be suited to preserving these resources in the long term, especially as the costs of protection will increase as sea level rises. In the revised document, we present a new case study of managed retreat to demonstrate how one community used buyouts over 3 decades to transform a portion of their built shoreline into a park. This example highlights that it is important to begin a sea level rise planning process early that considers both short and longer term impacts, so as not to preclude opportunities for implementing future adaptation options that may take many years. For purposes of implementing the Coastal Act statewide, no single category or even specific strategy should be considered the best option as a general rule. Different types of strategies will be appropriate in different locations at different times and for different hazard management and resource protection goals. In beginning adaptation planning, communities should explore all their options, and the draft guidance recommends a pathways approach using locally relevant triggers and vulnerability assessments to develop different strategies to address both near-term and longer-term impacts. FAQ number 8 has more discussion of the issue of managed retreat. So I'm going to shift gears away from the FAQs now to note a few other revisions to the policy guidance. In responding to comments, more detail was offered on the importance of coastal resources, with a new subsection on this in Section 1 to describe the coastal squeeze. The graphic on this slide shows how shoreline armoring can result in the loss of beach. More emphasis in Section 1 was provided to highlight the importance of infrastructure planning in many residential contexts, and the need to engage additional stakeholders in collaboration when conducting adaptation planning processes. Community participation in adaptation planning is also more prominently represented in a new subsection, Develop Adaptation Plan, in Section 2. We moved the case studies that were formerly Section 6 to a boxed part of Section 1 to demonstrate examples of the types of residential and geomorphology context for adaptation planning. While adaptation strategies should be chosen based on the specific risk and vulnerability of a particular region, in the context of applicable Coastal Act and LCP requirements, there are some policy concepts that are likely needed to ensure compliance with the Coastal Act in all hazardous areas. These are listed here, and the 3 dark blue topics are the ones that we added in the revision. So these concepts include using the best available science to evaluate and understand sea level rise, requiring risks to be disclosed, regulating redevelopment, avoiding and minimizing hazards through siting and design, planning for removal of threatened development in some circumstances, preparing for emergency permits, and, like I mentioned before, developing adaptation plans. After reviewing public comments and consulting with Commission staff and other agency experts, we presented some new model policies in Section 6. We also provided more user notes throughout this section. We placed more pictures and white space throughout the document and made edits as well for clarification. The comment response table that will soon be on our website will detail these changes quite a bit more than I will here today. So I want to remind folks that the comment period is now open on our revised draft, and we anticipate that closing on April 5th, 2018. Comments may be submitted by email to residentialadaptation@coastal.ca.gov, and this presentation will be posted on our website as well. After the comment period closes, we will consider revisions based on comments and bring a proposed final guidance to the Commission, hopefully in the summer. So thanks to everyone who called in today to learn more about our revised draft policy guidance. We look forward to receiving your comments and updating the revised draft. And we're now available for any questions you might have, and I'll turn to other folks in the room to help me answer some of those questions. All right.
So we have a question. Hi, all. This is Michelle Jesperson with the Commission. We have a question about viewing a version that shows a red line strikeout changes, and we can look at that, and we did something similar with our sea level rise policy guidance, so that shouldn't be too difficult, and we'll try to do that and post that shortly on our website.
And again, we will have the response to comments table, and that's about 90 pages long, so it goes through in great detail all of the comment letter suggestions and how we responded in changing the document.
There's a question about about the possibility of distinguishing between the responsibility of the Commission to look at the guidance and use the guidance and the responsibility of the local government. It looks like the commenter may have been looking at language about how the Commission will do something versus how the local government should do something. I think it would be interesting, I'm not sure whose question this is, but maybe if they want to send in an email and we can talk in further detail. We didn't intend to draw a distinction between how the Commission would use the guidance and how the local governments would use the guidance. As we've stated, it's not a regulation, but it does provide an indication of the Commission's direction on how local governments should be addressing sea level rise. And as we described, some portions of the guidance draw directly from Coastal Act requirements. Those would be things that need to be complied with, adhered to, versus some portions of the guidance that are making recommendations. And so we did our best to clarify throughout the document which is which. So I'm not sure how helpful that was. I think that if the commenter wants to submit an email to the email address, we can discuss it further.
So this is Aaron Chalmers. I'm an attorney with the Commission, and I see there's a question about the legal basis for the interpretation of Section 30235 and specifically how the term existing structure is defined. And I think you will find a fairly in-depth analysis of that issue in the FAQ response document. But briefly, some of what we go through is the interpretation of how sections 30235 and 30253 refers to new development, which in most cases should not refer on shoreline protective devices that alter natural landforms along bluffs and cliffs, and 30235, which allows shoreline protection for existing structures if certain criteria are met. And so reading those two together and looking at the history of the Coastal Act, we feel that this is the best interpretation that really carries out the intent that new structures should be designed in a manner that doesn't require shoreline protection that harms coastal resources, whereas the Coastal Act really seemed to, grandfather, in a way, existing structures that predated the Coastal Act and give them more leeway in terms of being able to obtain shoreline armoring that might have other impacts. So our FAQ does go through that in some detail in terms of those two provisions and how they work together. Something else we considered is just the Commission's duty to interpret the Coastal Act in the manner that is most protective of environmental resources and also that protects public trust resources. And as we've described already, shoreline armoring does have significant impacts in many cases on public trust resources, on public trust lands, and on various coastal resources. So again, the FAQ document goes into more detail about the legislative history, some prior Commission interpretations of this, and the fact that the Commission has really taken a fresh and comprehensive look at this issue through its sea level rise guidance as well as through this guidance.
All right, there's another question about how this document relates to the newly adopted OPC sea level rise guidance and the sort of updated sea level rise projections and best available science. So right now, the residential guidance doesn't explicitly discuss the OPC guidance, so I think we can probably add just a note noting that that's been sort of updated. But I will say more broadly, we've been coordinating with OPC on their development of their guidance, and we find that it fits in with the broader recommendations of our earlier Coastal Commission sea level rise guidance. So, that earlier guidance from 2015 talks about using best available science, which at that time was the NRC projections. We haven't specifically been figuring out how we'll update that guidance, but we are now considering the rising seas and the OPC report to be best available science now. And then further, I would say that those projections, although they've, changed a little bit, the high and sort of low projections from that OPC recommendation, they sort of fit in general with with the NRC projections, and then they've added that extreme scenario too. So again, that just all sort of fits in with the general recommendation to be precautionary, consider a wide variety of sea level rise projections when you're doing this sort of general land use planning, and then there's still a difference between planning for and considering these different projections and then actually designing, but then figuring out adaptation opportunities for if there's additional sea level rise. So again, we'll put more of a note in the residential guidance about sort of the new OPC projections, but just in general, I think we're all still coordinating on these questions anyway.
The next question that we have listed here is a request to talk some about how takings analysis may have impacted Commission staff's development of these model policies. Of course, takings issues are near and dear to the heart of many people, including us, and so we certainly were thinking about those issues as we develop these model policies. So one of the model policies is actually what we colloquially referred to as a takings override policy. So as you all probably know, the Coastal Act itself does not allow local jurisdictions or the Coastal Commission itself to apply the policies of the Act in a manner that would take private property without just compensation. So, you know, as a sort of a background principle here, we certainly acknowledge that none of the policies should be carried out in a manner that would, in fact, take private property without just compensation. But, of course, we tried to draft these so that they wouldn't be carried out in that manner in the first place. Trying to think of specific examples. I mean, you know, again, one of the sort of underlying principles here is that property, you know, coastal property, shorefront property, we want to be able to use, we want individuals to be able to use for as long as it's safe and as long as it's consistent with other Coastal Act protection policies. So, for example, you know, some of the model policies would allow for uses of land during the time that they are safe to provide people a reasonable use of their property, and to only require removal at such time as you know, high tide line moves, for example, or the property gets wiped out. So again, to just use it for as long as possible. Another issue in terms of avoiding takings is some of the subparts of, I believe it's policy A6. Is that right? Which suggests that conditions should be imposed on permits for development in particularly hazardous locations. And some of those conditions would require notice that it's in a hazardous location, acknowledgement of that, a deed restriction, you know, which would demonstrate that the owner and any future owners would be on notice that it's in a hazardous location, that the mean high tide line might move, you know, basically putting property owners and subsequent owners on notice of these hazards. And that sort of notice can reduce takings risk. If somebody is granted the right to build on the property, they should be put on notice what the restrictions are, and that can help limit their expectations about, you know, how long this development can remain. And I know there will be more detailed response on that particular issue in the response to comments table that we're putting together now.
Okay, we have a question about how the policy guidance would be applied on state retained jurisdiction. So in general, the commission retains jurisdiction over tidelands. Typically, tidelands don't have residential development on them. There are cases with filled lands and where the commission is the entity providing or approving permits, acting on permits. I would expect that the commission would be considering this guidance in acting on permits that are in its retained jurisdiction that relate to residential. Of course, it will be looked at. The Chapter 3 policies will be the standard of review. These will be used as guidance. Also, this guidance is written in terms of LCPs versus in terms of giving CDPs, and so there will be a slight distinction there. Yeah. I think that's our last question right now.
Yeah, there aren't any more questions right now, so definitely feel free to continue typing in questions. You know, we definitely have more than 20 minutes still scheduled for the webinar. So if anybody has any, I'll type those in. Doesn't seem like we're getting any more questions.
hopefully everybody who is registered for this webinar is on our mailing list, and as our further, and I think we have another question requesting a little bit more time, but I just want to remind folks to get on our Sea Level Rise mailing list if you want to be receiving notices of updates on the Residential Adaptation Guidance webpage. We'll be posting more materials there, so that's definitely a place that you can go to check out what the latest is, as well as just emailing residentialadaptation@coastal.ca.gov. And again, we have some more of this second comment period, so if you review our materials and you have further comments to make, please send us a comment letter and we will address those points that you make. And we're hoping to take the proposed final guidance to the Commission sometime this summer. And if you're on our mailing list, you'll get the updates about where we are in the process there. And we can give a few more minutes if folks are typing in some further questions. And also, if you want to have some time with members of the Sea Level Rise team to have a phone discussion, you can always email us at our residentialadaptation@coastal.ca.gov, and we can try to set up a personal time if you have a lot more you'd like to talk with us about as well. We'd be happy to do that.
Okay, there's a further question about this distinction between, so I'll just read. There's a line on page 3 of our response document that says the Commission will and the local governments should consider the draft guidance when drafting and reviewing future proposed LCP policies and when considering CDP applications. The distinction here between will and should was I believe only written because we as Commission staff can say what the Commission will do. We can say what local governments should do. We can't see the future, and so we don't know that local governments will do this. We assume that they will, but I think so. This was just in the way that the language is drafted. We weren't trying to draw a distinction here. The Commission will be using this. We expect local governments will be using this, and certainly the Commission will be using it as it reviews new LCPs and LCP updates that are coming through. So apologies for any confusion on that, but it wasn't meant to draw any distinction there.
All right. We can. I think that's pretty much all the questions, so we can touch back with folks if they have additional questions sort of offline as we continue going through the public comment period. So like Mary said, feel free to email at the email you see on the screen or get in touch with our own team. And yeah, pay attention to sort of how things stay on the mailing list and pay attention to how this is moving through, and we look forward to receiving everyone's comments.
Thanks, everyone.
All right, thanks, folks.